Ridgefield Inland Wetlands Board. Regular meeting. October 24th, 2024. IW 2419. 27 Abbott Avenue.
Okay, it's 7 p.m. This is the regularly scheduled Town of Ridgefield Inland Wetlands Board meeting for Thursday, October 24th, 2024. In attendance, we have Alan Pilch, Carson Fincham, David Smith, Tim Bishop, myself, Susan Baker, Attorney Tom Beecher, and staff member, Wetlands Agent Caleb Johnson. Okay, we have IW 24-19, 27 Abbott Avenue plenary application for the construction of 10 residential townhouses with associated drainage and landscaping within the upland review area of wetlands and watercourses. Owner Vitan Alimi, applicant Brian Carey. And where we left off was basically that we had still have to consider that this application also includes an intervener. And as I think it was explained to us that in the previous application, and Tom, correct me if I'm wrong, we are allowed to talk about the previous application and the denial as part of this discussion.
Absolutely.
And we did put the denial, the reasons for denial did go into the record for this application.
Right.
Yeah,
because the applicant made the point that they believe, and that's up to you to determine, that they addressed all the major concerns that this board had with the application.
Right. So as part of our denial, we listed what it was about the first application that we found to be the reason for denial, which were, thought I had that here, but I do have it here somewhere. Oh, shoot. Anyone have the resolution for denial in front of them?
I do. I can share it.
Thank you. I think it's a good starting point for this, and I don't know what happened to my copy that I printed out carefully here. Oh, no, I have it. I do have it. But we have it. It's kind of hard to read it on the screen, but can people read that? Okay, the relevant part here is after deliberating, the board concludes that there will be a detrimental impact to the wetland from runoff flowing directly into the wetland and the thermal effects of that runoff as well, particularly during hotter times of the year. The board's decision is also based upon the evidence that the stormwater management system will not sufficiently remove harmful sediments, chemicals, and substances prior to flows reaching the wetland. The close proximity of the outfall, as well as likely overflow runoff to the wetland during storm events, leaves little or no room for natural or other additional filtration before flows enter the wetland. Overall, the evidence establishes that the stormwater management facilities are located too close to the wetland boundary, and that close proximity will lead to permanent negative impacts to the wetland. The board concludes that to avoid unreasonable impacts to the wetland, a feasible and prudent alternative exists consisting of an increased buffer between the wetland and the limits of construction of at least 75 feet, a more robust planting plan, incorporation of LID stormwater management techniques such as, but not limited to, natural swales, and the relocation of the snow removal storage area. So that's basically what we said. So I guess we're here to discuss whether the changes that were made to the plan address our concerns. And I should add that both of our peer reviewers felt that this plan does address the concerns we had previously. So, anyone would like to speak to that? Floor is open.
I guess I'll start.
Thank you, Alan.
I guess my own feeling is that, the design firm made a attempt to address our comments previously, but my own feeling is that the current plan just has too many compromises in the design and the construction sequence, so that I really did question, and I know they tried to address those questions, but I expressed my concern that their stormwater management plan would not function as intended and would therefore impact the wetlands. A lot of it is due to the proximity of the stormwater management practice, the subsurface chambers, in such close proximity to the building that the soils would be impacted through compaction during construction and would therefore compromise their ability to function and to infiltrate into the ground, which is part of the way that they had claimed that they would be renovating the stormwater runoff into the wetland. Their design did not provide the required 3 feet of unsaturated soil below the chambers. Some of that distance was made up through the stone, which is placed under the chambers, that 3 feet. So they actually had less than 3 feet of soil in that location. Part of it too was the deep hole testing, which showed a variety of the deep hole testing done in the proximity of the proposed chambers for stormwater management, which showed items like glass, brick, ash, slag, organic layers, things like that, which are, I'll just say, not conducive to renovation of stormwater runoff. I know I expressed another some meetings about the wall, the 5-foot high wall around the perimeter of the project, and its impact on amphibians in the wetland. I know that's probably not, I'll just say that was my comment. And I also don't feel that I know we made mention of relocating the snow storage area, but I also think that the snow storage area that they provided is infeasible and would not be used by any contractor in clearing that site of snow. So I think with all of those items, I don't feel comfortable with this current design.
Mm-hmm.
Namely because I think altogether they will impact the wetland negatively.
Mm-hmm.
And their attempts to do something like their rain garden, I don't think was an interesting attempt. I don't think is well thought out, and the design I don't think will function as intended.
Mm-hmm.
Oh, lastly, I'll just say I thought their planting area was sparse, the term I'll use. I know they tried to beef it up, but I still think it's very sparse between the disturbance area and the wetland itself.
Thanks, David.
Yeah, I just have a question for Tom. We engaged 2 peer reviewers, and I guess I don't know historically, is it completely the weight that we would give those reports, is that completely discretionary by the board? Is it for advisement only?
As between experts, you do have the flexibility and discretion to determine which expert you find to be more credible. So if you are making a determination between, I forget Land Tech's wetland soil scientist, and between that person and Megan Raymond, who's your own expert, who's not in it to make money for a developer, and Mr. Danzer, Dr. Danzer, you get to make a determination between those 3. But, you know, as I say about every application you ask me about, I mean, I have to think about what is a judge thinking when a judge reviews this record and transcripts and says, well, Megan Raymond gave you a detailed report. Land Tech made substantial changes to their plan in response to her report. They also provided a detailed response to her report. And she finished up by saying, they've addressed all my comments and concerns, and I would just suggest that you, as a board, adopt the rain garden and adopt the conservation restriction. So what do I tell the judge about that?
Thank you.
Tim?
Yeah, I'm going to echo Tom's point because I just received a 42-page memorandum of decision from Judge O'Hanlon on a controversial appeal case, and 42 pages is pretty lengthy as far as the ones I've seen. And he pointed out on page 41 that even the experts retained by the board agreed that there were going to be no adverse impacts, and that information was on the record. So it was, not saying that's the only reason, but that does get looked at by the judge, you know, I think with some weight. So as the experts we pay and retain to provide us with accurate, unbiased information, you know, I know we can make our own decision, but at the same time, again, I'm torn with this one, with fears of flooding and in a higher density area of town. That agreeing with everything Alan said, I'm torn again. Like, you know, this area does flood, proximity to the water course. This is a difficult one, and I don't want to make a decision just based on fear of record or appeal or a judge's decision, but yeah, that's all I have to say right now.
Tom, did you want to add
Just
something to
wanted to
that?
interject on that one point. You know, if flooding from the project is going to cause significant adverse impact to wetlands or a water course, then you're on point. But beyond that, stormwater management systems is more of a planning and zoning issue, which they will have to take up on this project because planning and zoning hasn't touched this project yet, as I understand, this particular plan. So,
Correct.
you know, flooding concerns generally, that would be a planning and zoning issue.
Oh yeah, well, to clarify, Tom, flooding as it relates to the system, stormwater management.
Alan?
I was just going to say that civil engineer, namely me, might disagree with our peer review civil engineer and with the conclusions. I'll leave it at that. You know, I too have extensive experience doing stormwater management planning for 40 some odd years. So we can have disagreements about it. So I'm just providing you, Tom, with a little context.
And your
Carson?
your CV was in the record, I think, right?
You're muted,
I
Alan.
believe so. Sorry.
If it's not in it is in the record in that he stated this more than one time during the process. That's sufficient, is it not, Mr. Beecher?
I've seen the CVs entered into the record for at least Alan, and I think somebody else as well. So I think if
Right.
you're going to rely on your expertise as a board member, I would recommend you always put it in.
Yeah, it should just always be a collection that goes in every application. So Caleb, if you could make sure of that in the future.
This wasn't why I raised my hand, but I think if I recollect, the intervener at perhaps the last meeting requested that the record from the the original application be put in this record in its entirety. And I know our CVs were in the original application.
That's probably where I was.
Okay.
So I raised my hand. I have a question for Tom with respect to that. Because I too am a civil engineer, but Alan has much more experience than me, and I greatly appreciate his opinions on things. And so this is the question I have with respect to kind of the legal standard of where we're at. The system as designed for me, and perhaps it's because I'm, don't have as much experience in the field, but I do know. So if it could work the way it's designed, that's one thing, right? If there's a chance that it would fail, and when it fails, it would negatively impact the wetlands, which I have a suspicion, and both based on the technologies they use and the way they have it set up, that is a possibility. I don't know whether it's a likelihood or not. I think Alan seems to think that's probably a likelihood. So that's my question: is as designed, if it worked, I think maybe the impacts on the wetlands would not be so great. My concern is that if it fails, then the impacts will be greater. And so my question is, I guess, is that fodder for having a strong stance for denying an application, or does the law treat it more like, well, you have to accept it as designed and assume it's going to work, and then if it doesn't work, you just you find them in violation and fine them, which I'm hoping is not the way that it's set up, but I'm questioning it because I don't know.
Well, the proponent of it is telling you that it's going to work and they're going to put their civil engineer stamp on it. So unless you've got specific contrary evidence in this record, that in fact there is a significant likelihood that this system just will not work and will fail. And therefore, not only that, but whatever the effect of that failure is going to significantly impact a wetland. So not only do you need evidence in this record that the system, in fact, will not work, even though the applicant says it will, but what's that impact of it not working? Is there a real impact? Or is it just nice water going into the wetland and then getting filtered and not impacting anything? So those are the two things you're going to need in this record. If you say, well, I suspect it may not work. And that's speculation, conjecture without more.
Well, yeah, I appreciate that. Thanks, Tom. I think Alan's given us some good reasons why he, as a professional with his experience, thinks it's probably not going to work. I think and he can correct me if I'm wrong, I think he thinks there's a high enough likelihood that it's not going to work, that he's got problems with it. I believe the intervener has similar issues, if not more issues, that they expressed about why they think it's not going to work. I understand those issues, and I don't know what the likelihood of them is. I know that I'm fairly certain from my training and experience that if it does fail, there will be significant impacts to the wetlands. So for me, it's just trying to measure that likelihood, and I guess weighing the evidence of the people that have testified as to what the likelihood is that will work or not work would be. One of the aspects, I think, weighing against applicant's testimony, and I think then this goes back to one of the conditions that we put in there. Maybe it wasn't phrased as precisely as it could have been, but we had requested that they not only stay at least 75 feet away from the wetlands for the various reasons listed, but that they incorporate LID in the design. It could have perhaps been more specific, because I know, at least in my mind, when we asked them to do that, and certainly currently, and in accordance with the new, the updated drainage manual, the LID elements are supposed to be the first elements that the water goes into. You're supposed to consider and use structural BMPs, which a Coltech is, after you use LIDs if you need them. And the applicant's testimony was that Coltechs were LID, and I strongly disagree with that. So that for me is reason to find suspect some of their findings. And I have not had any such concerns with Mr. Pilch or with the intervener's evidence that they put forward. So that's a long way of saying I think I'm leaning a little more to Alan's side.
Anyone else? Okay, for argument's sake, if you had to put together the reasons for denial, in this case, how would that be worded? Because we're basically arguing that there would still be unreasonable impacts to the wetland, and that a feasible and prudent alternative exists, and right now they have everything at least 75 feet away, and so they did increase the buffer. I mean, the planting plan could probably be dealt with, I don't know, in possibly be dealt with in conditions. So it's basically the non-incorporation of lid stormwater management, and something about the system is the system that wasn't mentioned last time as being a problem, except that it was too close to the wetland. Is there something different this time about how they're managing the Coltechs from last time? In other words, they didn't take the same thing and move it back further away. They did something different, or the location they put it in now is different from the location relative to buildings, whatever, that we had before. You see what I'm going for there? I think we have to address.
Yeah, I see
that.
I see what you're saying, Susan. The again, perhaps the denial wasn't as verbose as it could have been. I'm not sure it needed to be, but it I think that's captured in the request that LID be used, and perhaps they took it to mean, or at least the way they changed the system to be, was that there is something LID in the drainage chain, right? But it's at the end of the chain, and it's within the vegetative buffer, really. So we had asked for at least a 75-foot vegetative buffer, which we have to a large degree now, and the use of LID. Presumably the LID would not be within that buffer. That was my understanding as to how that was drafted. And I think currently the LID is in the buffer, and it's the structural BMPs that are outside the buffer, but those are the ones we had said should be LID, not structural BMPs. So I think that's where that's captured. That difference is that the system itself, and that there are also some, every time all the engineering plans are hashed through, right? There are issues, like Alan said, with the gravel base under the Coltechs and distance to groundwater. That I think is possibly changed from the original application, or I know there were some questions about that in the original application as well. I just can't remember what they are. But the long and the short of it, I think, is if you're not using the Caltech, if you're using LID, then those issues go away to a large degree. So not incorporating the LID as an upstream kind of mitigation member before you get to the buffer, which was my understanding of as what the way that was written was supposed to cover. That I think is not quite met by what they've proposed here.
Okay, so buffer was increased, limits of construction 75 feet. The planting plan, there's been some discussion of it not being robust. There is the LID stormwater management was not put where we would have expected it. And then we also have the snow removal storage area being basically not credible, not feasible. But basically, I'm just having a little bit of problem figuring out how you would word this second denial. Oh, and just out of curiosity, Tom, the one that's with the court right now is the original one.
That's correct. Yeah, right now it's the court has been kind enough to allow the scheduling orders to be pushed out in the event that this application might get approved, so that then we wouldn't be spending legal fees on that particular appeal. But if not,
Right.
then the staff has to get the transcripts done and put the record together, and off we go on that appeal, and likely a second appeal, which, you know, I'll just have joined together. On a different note, I want to circle back to the planting plan, because I noticed that Megan Raymond had suggested a more robust and different plan with different plants, as opposed to the original sort of unified planting plan. And I believe they submitted a response to her request for that. So when we talk about the lack of a robust planting plan, I just want to be sure you're talking about the final submission that Megan Raymond said was fine and addressed her concerns. And consensus, although I don't know that we're there yet, if the consensus is for denial, I would suggest continuing this meeting and asking the board members to actually make some notes of how specifically the facts in the record that support a finding that there will be permanent adverse impacts to wetlands as a result of this project, and or point us to experts, including yourselves, who have opined to that effect. Because to just have staff with my assistants go off to draft something, you know, it's a lot easier, because it's got to come from the board members as to what their collective reasons are for denial. So I think if you draft those things as to what the problems here are and how that actually is a provable case of impacts to wetlands, then you can discuss them as a board, and then staff can put them in writing, if that's the direction you go. If it's for approval, then obviously you can talk about conditions such as the restrictive covenant, the rain garden, maybe some other tweaks to the wall or whatever you might think can work.
But I guess my other question is, going back to the fact that it's the earlier application that's in court. In theory, could a judge order us to do that original plan?
Yes,
rather than
Yeah. if the
I'm
judge-
sorry?
Yes, if the judge determines that there wasn't sufficient evidence in the record supporting the denial.
Right.
Susan, by
So-
original, you mean the previous application?
Oh, yeah, the one with
Okay.
14 units and 25-foot buffer.
I was just clarifying that you weren't referring to the, I think it was 3 units or something that was
No, that's
an
not what's with the
alternative during
court.
the first application.
Right, what's with the
They
court
already have
is,
approval for that. Okay.
they do. Yeah, they don't have, there would have been some issues to deal with there, but they have approval to put that building there, yes. Going back to when, before our 100-foot
Before our time.
review area, yeah, before our time, exactly. So, no, the one that's in front of the court that the judge would be
Okay.
ruling on is the one prior to this one. And I think that's a significant consideration here also. So the question then is, I think Mr. Beecher is correct. If people are considering, if some of us are considering denial, we would have to come back with very specific wording for Mr. Beecher to use, and keeping in mind Tim's comment about the 42-page ruling that he recently saw.
Yeah,
You
it's
know,
all
it could
about
be
the record. As
It's
we
all
know.
about the record, and
So,
I think
tough.
then we would definitely have to schedule a special meeting, because we would need to be able to get that together before we have the final vote. And it would require going back through the record, which of course we have, but it's voluminous, and finding the evidence within the record, supported by the record, that we are going to state as reasons for denial in this case. So are you up for that? Do you want to go that route? That's the question.
If that's the consensus.
Right. And that's the
I-
question. Do we have a consensus here at all?
I have a question for Alan.
Yes.
If he recalls, or anyone recalls, but to you, Alan, the discussion about compaction and stone thickness or material thickness in the subsurface below the Cultex, was that obviously it wasn't addressed because it's a point of concern for you, but I don't recall that discussion, word for word, but was that modified or how did that discussion go?
I think I brought it up in a meeting and they responded to it in one of their memos.
Mhm.
Okay.
Right, their memos
Um,
tend to cover,
And I just disagreed with their assessment.
yes, I believe there was a discussion as to whether that could be checked during construction to make sure it would actually work.
And that's what I was saying. I just think there were so many compromises in their design.
Mm-hmm.
Where, if they had I hate to say it, but if they had design that worked up front, I wouldn't be worried about these items. But because of the site layout and the extreme likelihood, that's the term I use, or the absolute likelihood that these would be impacted, I wouldn't have this concern. But because I really do feel this way, that's why I'm saying I don't think it will function, not as intended, as designed. So I think the result will be very specific impacts into the wetland that could be quantified. .
Anyone else at this point? Carson,
Just not really any additional input, just a question regarding the intervener. Is that something we have to decide on now and or separately, or is
You will have to decide it separately. You don't have to decide it now. But they go hand in hand, particularly with a denial. But you just need to address that just prior to then voting on your final decision on the application itself, because the intervener status, if they have proven their case, also requires you to make findings about feasible and prudent alternatives.
thanks.
right,
Yeah, and if I haven't sent a memo out on that, I'll send one out. I would also just ask everyone if they still have it. I'll send that out again. I sent a memo out in May on just generally, you know, what the board's role is in assessing credibility of witnesses and you know what your role is in actually determining impacts. So I'll send that out again as well.
thank you. That will be helpful. Do I have agreement, at least amongst the members, that we will find a time to put in a special meeting then? While members work on specifics. That's a yes. I mean, I think there's definitely, this is a good discussion, but we need another discussion. And we need to come to that discussion prepared with, you know, to support our point of view, individual points of view. So that we still have time to ask the staff to draft either a resolution of approval or denial. And don't run afoul of the time that we have. Is everyone agreed to that? Yes? Tim? David? Okay. I believe that's what we will do then. We will get back to members as to what date would be appropriate to schedule a special meeting in order to continue the discussion. Thank you. Appreciate that. I think we've reached as far as we can get this evening.
This is Kirk Carr, on the record. Thank you for watching.